I could use a wig.
Okay.
Good afternoon. I am Wendy Rutherford of the Nashville Bar. It's good to be in front of you again. This is a termination of parental rights in an adoption case. And
Do you
the
want to
issue-
reserve any time?
Yeah, oh, thank you, Your Honor. Yes, 3 minutes.
3 minutes.
The issues that we are raising on appeal, one has to do with whether or not the trial court erred in failing to find that we had proved by clear and convincing evidence a failure to manifest under Tennessee Code Annotated 136.1.113 G14, a failure to manifest a willingness or ability to take physical custody or financial responsibility for the child and placing the child in the legal or physical custody of that
And
person.
that fell on the substantial harm component.
A substantial harm. It
Yeah.
failed on substantial harm, correct. And then the other issue that we have raised in our brief is whether or not the trial court viewed the best interest factors from the child's perspective. Just as a little history on this case, Daisy was born in October 2016. When she was born, her father is the petitioner's grandson. They came home and they lived in the petitioner's home with her. The petitioner helped care for Daisy from birth. In December of 2017, the mother had another child who was born drug exposed, and both children were removed from her care. Daisy was placed with the grandmother who had previously cared for her and has been in her physical custody since December of 2017. In November of 2018, there was an adjudicatory hearing in the Davidson County Juvenile Court, and legal custody was given to her. Mother was given some therapeutic visitation, which she exercised some of that. In 2019, I believe it was June of 2019, at the final dispositional hearing, the court gave the petitioner legal custody and made the determination that the provisions of Blair v. Vadenhope would apply. In other words, that the mother would have to come back and prove a material change in circumstances to modify that order. And visitation was at the discretion of my client. The mother did not visit, did not contact, did not pay support after June of 2019 until September of 2023.
Counsel, in terms of thinking about the best interest, and I want to ask opposing counsel this question also, it struck me that the trial court's analysis seemed to center significantly upon the idea that there's not going to be any kind of change of custody imminently or immediately. It may be long down the road before that occurs. Is that an appropriate way for thinking about the best interest factors in terms of assessing them in light of nothing's really going to change on the ground right now? Is that how they should be analyzed? Is that how they shouldn't be analyzed?
I will say that the statute says in Section I of 113 says that the prompt, permanent placement of the child is deemed to be in the child's best interest. And in this case, this child had been in my client's custody physically since 2017. And between 2019 and 2023, there was no contact. At the time of trial, this child was 7 years old, so the contact that she had had was when she was very small, less than 3 years of age. So what the court was saying it was, because this child has been, the testimony was she was resilient, she made friends easily, she was a good child, which I would argue was a result of the nurture and raising that she had had. She's able to handle this change, this upheaval. She calls her custodian Mama, but we're going to introduce someone else to her and have her call that person Mama, somebody that she's never seen before, but she doesn't remember. The child's mother acknowledged she probably wouldn't recognize her. She acknowledged that it would be traumatic for her to be taken out of that home. She also testified that her long-term goal was to get custody of her child back. That is disruptive to what we understand children need.
The list of factors that are set forth by the General Assembly is not exclusive. In the other sort of considerations category here, the trial judge, one of the things trial judge expressly touches upon is the more advanced age of the child's caretaker here. Does that affect how those factors should be looked at? Not just sort of that question in isolation, but does it shade into the analysis of all of the listed factors themselves?
This is a relative adoption, first of all. These are not two strangers, and the parties are aware of who each other are.
But at the end of the day, though, there's going to be a termination.
There's going to be a termination, but as people, I mean, I do a lot of these cases, and I mean, I'm not, my
So do we.
right, my
Sadly.
statements aren't evidence, but when
Yeah.
you're dealing with families and adoption, interfamily adoptions, there's not ever a clean cut. It's just not, it doesn't happen. People know who each other are. An answer to your question, Judge, the advanced age of the petitioner should not have come into play. The testimony was she's healthy, she is active. There is no reason to assume that she's unable to do what she needs to do. If this child finds herself, I mean, there's no guarantee that tomorrow the perfectly healthy people, I can walk out and get run over by a bus. There's no guarantee that any of us are going to live through our children's minority.
But certainly, as you pointed out, stability is one of the things that you're supposed to be looking at in the child's best interest.
Continuity, predictability, the consistency of the placement. And what the trial court did in this case is it was very impressed, and I'm throwing no shade, that the mother had overcome drug addiction and was looking at the best interest factors from the perspective that the mother has done these great things. But what the trial court should have done and needed to have done was look at what has the child been through. And I think it's significant that the mother testified she got sober in 2020, she became employed in 2021, and she didn't reach out to make contact regarding her child until September of 2023. In our statute, if a child is over the age of 4 years, 4 months is grounds of not having contact and visiting or paying support is grounds to terminate parental rights. There was no reason. You know, the court is very complimentary of the mother's efforts on that behalf, that she had a lot to overcome, that she had gone to rehab and done these different things. But it took her 3 years after she got sober to reach out. And at that point in time, you have a child who does not know who this person is, who has
The law
enjoyed.
requires that we look at these factors in the best interests of the child, not the parent or
Correct. Correct.
How do you do that?
Well,
Is there a case in Tennessee that says how you do that?
Well, White v. Moody it's about 20 years old, but it is still good law. And I'm real familiar with White v. Moody. I argued it 3 times in front of this court before I finally lost it. In that particular case, this court said that, you know, ascertaining a child's best interest of cases of this sort does not call for a rote examination of each of the factors, and then to make a determination based on the weight of them. And depending on the circumstances of a particular child and a particular parent, consideration of one factor may very well dictate the outcome of the analysis. And in that particular case, the father was bipolar. And as a result of his bipolar illness and as a result of just his instability, he went a very long period of time without visiting his child. In fact, he went 5 years without visiting his child. In the interim, he got his act together. He did get his act together. He made good progress, but by that time, the damage had been done. And they were talking on the telephone. They were having conversations on the phone, but they weren't substantive, and they were not. And this court found that the fact that there was a lack of relationship was clear and convincing evidence that it was in the child's best interest to terminate his parental rights. So that case has not been, it's cited regularly for the proposition that we don't do just a rote examination. There has not been any case law since then that says that that is not good law. And I think those facts are very similar to the facts that we have in this case, that it took a very long time for the mother to get her act together to do what she needed to do to be able to have a stable life and to parent these other children. And that's great, but we're not talking about her. We're talking about Daisy. And Daisy has been in a safe, stable environment since 2019, or since 2017, excuse me. And her life should not be disrupted. And we need to look at those best interest factors from her perspective. Quickly, I want to say with regard to failure to manifest, this court has repeatedly held in Isabella G., Gabriel T., Logan F., that forcing when a child is bonded and attached in a permanent or a stable environment, forcing them to begin visitation with a virtual stranger can cause psychological harm, the risk of psychological harm. And for that reason, the failure to manifest ground should have also been found. But I'll come back in a couple of minutes.
Thank you very much.
Good afternoon, Your Honors. Brandon Booten on behalf of the appellee, Ms. McCaslin, from the Sumner County Bar. Your Honor, regarding the failure to manifest, I want to touch on it very briefly because it is the first ground that was brought up on appeal. The language in the failure to manifest ground requires that the child be placed back in the legal and physical custody of the parent. And placing that child back in the legal and physical custody of that parent would pose a risk of substantial harm. In this case, it was very clear at the trial level. The mother in this case is not asking for an immediate return of custody to her legal and physical care. She's asking to establish visitation at this point. That visitation, that petition that she filed, was thwarted by the petitioner in this matter because the petitioner showed up to court. There was supposed to be another court date scheduled. There was supposed to be a mediation scheduled after that. She did not do any of those things. Instead, she filed her TPR petition instead. And when she filed her TPR petition, I do want to address the fact that it's a TPR petition, but it's in name only. And I say that because the father in this case, and it is very clear at trial, is going to continue to be in this child's life. The child is going to continue to call him daddy. The child is going to continue to know him as her father, even though he's consented to this termination of parental rights. It's not a TPR across the board. It's a TPR to thwart mom's visitation. And so when you talk about the best interest of the child, I don't know how this court or any court can look at this and say it's in the best interest of this child, or any child for that matter, to have these disparate factors across the board, to have mother's rights terminated to her completely, but father's rights to remain intact. And again, the testimony at trial was that the grandmother said, the petitioner, she will continue to know him as her dad. She will continue to call him daddy. He will live in my house when he gets out of jail with the child. He will have to show me that he's changed his ways, but she will continue to know him. So when I say...
I want to ask you the same question I asked
Sure.
opposing counsel, which is, I was very struck in reading this order that the trial judge was very much thinking about this in terms of that lack of transition that you just referenced. And I'm trying to figure out whether that is appropriate in terms of analyzing the termination grounds, in terms of analyzing best interest. And I mean, you've raised the argument here that, there's not this substantial psychological danger because the child's not about to go to mom tomorrow, so therefore the risk that opposing counsel references isn't as great as it may seem, or the best interest factors aren't as problematic on that front. Is that really the way this is supposed to be analyzed? Is that really the way the trial judge is supposed to be considering the factors and considering the grounds?
So I think in all of these cases, certainly it's fact specific. So while in one case you can say, well, we can't look at it from that aspect, but in this case you can. And again, I think that's clear in all our TPR cases. To your point, I think you had asked the question earlier about, and correct me if I'm wrong, but I think you were asking about the age of the child. Should that be considered as far as the best interest factors, or were you asking about the age of the petitioner?
Age of the petitioner
Okay.
here. And so I took it as that was one of the trial court's considerations here in terms of the other considerations that are not statutorily
Sure.
specified.
Again, I think it's fact specific based off of every TPR that you have. I will say that in TPRs, in all of these cases, there is a guardian ad litem that's appointed solely to represent what is in the best interest of the child. And in this case, the guardian ad litem acknowledged that there is a distinct benefit to the mother restoring a relationship with her child. That's her entire role, is to argue on behalf of what is in the best interest of the child. And that's in every TPR case. That's required by statute. It's required by Supreme Court rule. So the general question that you're asking, I think I can't answer without saying it's a fact-specific scenario. I understand the thrust of your question, and certainly I think the trial court in this case did analyze mom's actions and what she has done in this case to overcome her addictions, which has certainly should be lauded. But to your general question of whether or not that's the proper analysis in all of these cases, again, with it being so fact-specific, I can't give you a blanket yes or no answer.
So your position would be that it varies based upon the case, that here it's an appropriate consideration given the particular facts of this case.
And I think, yes, and I think that's very pertinent to these types of cases, because the TPRs are so varied in their facts and they're so across the board with the facts. I don't think it's applicable to apply a blanket analysis without looking at each fact-specific case.
You wouldn't disagree, though, there's a significant volume of cases from this court where we've said that where there's not that the most important consideration is existing relationship. There's not an meaningful existing relationship right now from the child's perspective here. And so given that, that termination would be in the best interest. I mean, there's more than a few of those that this court has decided, even where circumstance where mom or dad has really managed, like in this case, to dramatically change their circumstances.
I would agree that's the thrust of the cases. I think it has to be analyzed on every fact-specific case, on every case that comes before the court. If that answers your question, it may not.
So this one's different, basically, because of the particular circumstances here.
I think all the TPR cases are so fact-specific that yes. So going back to...
I've got a related question about that. That if you look at the factors, even aside from the point about this sort of, pretending that, it's probably not the right way to put it. If you look at individual factors the court does analyze, the court concludes with each one. This one favors mother. This one favors petitioner.
Sure.
To me, that's a little bit like nails on a chalkboard, because everyone is saying, seems to agree that we're supposed to be looking from the standpoint of the child here. And that, to me, is a signal right there that these factors weren't weighed with the child's interest in mind, but rather with the petitioner respondent's interest in mind.
So I think you have to look at the actual language of the factors themselves, because the factors themselves spell out what exactly is to be examined by the court. Specifically, one of the factors is the emotional attachment or the relationship specifically between the parent and the child, and not the petitioner and the child, but the parent and the child, and whether or not there's a reasonable expectation that they can have a lasting attachment going forward. That language right there alone specifies that you have to look at the relationship between the parent and the child. It's not just from the child's perspective, it's also from the parent's perspective as well. So the general language, the general analysis is from the best interest of the child, but the specific language and the factors themselves show the analysis the court has to engage in, if that makes any sense at all.
Well, that's essentially why I asked the question earlier about how do you decide the best interest of the child? Because a lot of those factors are really viewed with the parents in mind.
And again, I think that's just based off the language and the factors that you have to do that analysis. But also, again, the best interests of the child are protected and argued for and advocated for by the GAL in the case, the guardian ad litem. And so with that analysis as well, that's really how you analyze what's in the best interest of the child is listening to the guardian ad litem's arguments, looking at the and again, it's so fact specific. Like it's hard for me to articulate a broad across the board application for these factors because every case is so fact specific. Like you can't just look at it and say, well, looking at it this way, mom hasn't had any visitation in 3 years. Well, she hasn't had any visitation in 3 years because that visitation was thwarted by the petitioner in this case. So you have to look at why there wasn't any visitation.
It took mom rather a long time after getting her life together to come back into court and seek visitation and to reach out to
It absolutely did. But here's the thing with addiction is that everybody's addiction journey is different. If the General Assembly had wanted to prescribe in the statute or in the best interest factors, after X number of time, if a parent hasn't petitioned the court or regained access to the child, that's a ground for termination, or that's a best interest factor that should be determined. The General Assembly would do so. As Ms. Rutherford pointed out, for abandonment, for failure to visit, the General Assembly has said there's a 4-month time period or a 3-month time period, depending on the age of the child. There's other areas of the statute where the General Assembly has said, after X amount of time, if this isn't remedied, you can file for dependency and neglect, or you can file for termination. They have not done so in regards to addiction because it's impossible to do so.
Best interest considerations, though, haven't they specifically told us that the courts need to consider the urgency with which mother or father acts in terms of addressing these?
Yes, they have done that. And all I'll say to that is that, again, every case is different. So mom has completely turned herself around, but yes, it did take her a while to do so. She conceded that point at trial. It took her a while to come back in the child's life. But she did still come back in the child's life. And then even after that, her actions were thwarted by the grandmother or the petitioner to seek visitation, receive contact, whatsoever. So while, yes, she absolutely did take her longer than normal to come back, or longer than expected, I should say, but she still did it. And there's no prohibition against that in the statute for best interest. So going back to the failure to manifest, again, that language is very specific, and it requires that the child is to be placed back in the legal and physical custody of the parent. That is not what is being asked for in this case. Mom is simply asking for that relationship to reestablish with the child. She's not asking for a return of custody right now. She's not asking that if the court were to deny the TPR, the child be placed back with her immediately. That's not what she's asking for. So that failure to manifest ground does not apply here.
So in your view, the flexibility applies to the termination ground itself also in terms of timing, in addition to best interest analysis? And are we assessing if the child was placed today with mom, what the risk would be? Because then if the child's placed today, opposing counsel has a fair amount of authority that would support that psychological harm concern.
I think for the failure to manifest ground, yes, that language is specific. It does require an immediate placement today.
Okay.
But
didn't the trial judge then err in thinking of, in considering, well, it's not a psychological, it's not a harm because we're not transitioning anytime soon here?
no, I don't believe so, because again, mom is not asking for an immediate return to custody today, even at the time of trial or whenever. So she's asking for that ability to reestablish that relationship that has been thwarted by the petitioner. So that language that's in the failure to manifest ground 36-1113G14 requires the immediate return to custody and how the court should examine it at that time. Nobody in this case at all has been asking for that. That is not, it was not the intention of the mother at the time of the TPR trial, and that's what gets lost in these TPRs, is that like Ms. Rutherford, I have done numerous amounts of TPRs. And it's not just it's not a TPR trial, it's not a question of, all right, well, if we deny the TPR, is the child going back to the parent today? No. That's not what a TPR is asking for. In this case, mom has been very transparent from the beginning of this case. She is not asking for an immediate return to her custody. She's just asking that her parental rights not be terminated so she can establish that bond with the child. She is not asking for the immediate return of custody, which is what is required by the failure to manifest ground. So all of these things being considered, and I don't want to elaborate too much because it's in the brief. The best interest factors are written out in the brief, and I can't expound upon that any more than I've done so in the brief. But all of these things considered, and especially again with the appointment of the guardian ad litem, who is appointed for the representation of the child's best interests, the trial court found that the mother's rights should not be terminated. And again, if I were standing here today and the posture of the grandmother was different, if she was saying, I'm terminating my own grandson's rights as well, he's not going to have contact with the child, she's not going to call him daddy, she's not going to remain in her life, she'd be in a much different posture than she is right now. But because her inability to cut father out, not just cut him out, I mean, her testimony was that the child will continue to call him daddy.
Isn't that more of a fairness issue between parents, though, than a best interest of the child issue? I mean, the grounds, and ultimately, we're concerned about the best interest of the child, not, I mean, maybe this sounds harsh, but I mean, it's not about fairness to the parents. It's about the best interest of the child, isn't it?
I don't know how any court could look at that and say that's in the best interest of the child to call her father daddy and not have any knowledge of who her mother is. Especially the dad who's been incarcerated this whole time. He's done nothing to clean up his act or rectify his situation. This child is, at the time of the trial, was 7. She's going to get older. She's going to have questions. Her questions are going to be, why are you daddy? Where's my mommy? Mom has done everything to rectify her situation. I understand that you're looking at that from the fairness of the parent's perspective, but from the best interest of the child's perspective, I don't know how any court can look at that and say this is in the child's best interest to continue to have a relationship with her daddy who's been incarcerated, and then she's going to have questions about who her mommy is. She knows of her. She knows who she is. The statement that she does not know who her mommy is false. Based off the testimony presented at trial, she knows of Sadie's existence. She knows of mom's existence. She knows she exists.
You wouldn't, and the trial court did find, though, that there's not currently a healthy attachment between parent and child in this case. Between
Trial
child
court
and
did
parent.
find that, yes. Yes. That's my time.
Your time is up. Thank you
you.
very much.
So with regard to failure to manifest, first of all, if a child is visiting with a parent, that child is in the physical custody of that parent. It may not be in the legal custody, but they have a legal right to visit if it's court ordered and the child is in the physical custody. This court has said in Isabella G. and in Gabriel T. and then again in Logan F., regarding the second prong, and this is speaking specifically to failure to manifest, this court has previously held that when a parent is essentially a stranger to a child and the child is thriving and bonded in his or her current household, forcing the child to begin visitation with the estranged parent is likely to cause psychological harm to the child. That's the situation here. We are going to force a child who has not seen a parent since before she was 3 years old to begin visitation with someone called mommy. And this court has held repeatedly that that is likely to cause psychological harm to the child, which is what the statute requires. And I believe that that has been met by clear and convincing evidence. With regard to guardian ad litems, we have judges for a reason. Guardian ad litems have ideas about what's in the child's best interest that may or may not be what the court agrees with. And I want to address the fairness question between the parents. During the incarceration, this father maintained regular contact. The testimony was he maintained regular contact through phone calls and other things during his incarceration. He also, when his father died, he came into an inheritance and he paid support. He did both of those two things. The mother did neither of those two things. The child has an ongoing, existing relationship,
Counsel,
and it's not about fairness.
Is the basis of the decision here, the trial judge is looking out and saying, Mom has dramatically reformed her circumstances. She's significantly improved. She's on the road to recovery. She's been doing well for years. She's providing good parenting to 2 children. I don't think there's really any danger to this child in terms of if the child was to be in that home, and the child's not anytime soon going to transfer. But here, grandmother who's taking care of the child is of a more advanced age. And so I don't want to terminate this parental relationship given that there's no clear plan in terms of how this proceeds, given grandmother's advanced age. Is that what's going on in this decision?
In my opinion, Your Honor, what's going on in this decision is that the trial court was very impressed with the strides that the mother had made and did not want to terminate because of that, and did not consider what termination meant for this child, that the prompt, permanent placement of this child is presumed to be in this child's best interest. And there is a plan. There is a plan if something were to happen to the petitioner, that she has made arrangements with other people who can step in and be guardians. The fact that the child has a relationship with the father, I think, is an ongoing relationship and has had one for years. The fact that she's not willing to cut him out, and he's her grandson, that there's a difference. This is a family adoption. The bottom line is that this child does not know who the mother is, and the court is willing to disrupt the continuity of the placement, the security and stability that this child has had, and to put doubt into this child's mind as to whether or not she's going to continue to be able to live with the person she knows
The
as
court
mom.
heard from this child, though, correct? The court heard from the child?
No, sir. The
No.
child did not testify. The child was only 7. The child did not come into court. There were other witnesses that testified as to the significance of the relationship.
Okay.
And the mother herself said it would be traumatizing.
Well, your time is up. Thank you very much.
Thank you. Your
Thank you
Honor.
both. That concludes today's docket. So would you please adjourn court?